Hello guys, so we have some update about NewJeans case, NewJeans versus ADOR, because court has made a new decision. Well, not entirely new, but it's something new that we didn't know about. Okay, and today's key phrase is this: NewJeans hit with indirect enforcement order, 1 Korean billion penalty per violation. And now, indirect enforcement order or indirect compulsory enforcement refers to legal mechanism where the court imposes financial penalties for non-compliance, pressuring the party to fulfill their obligations. And this is something that a lot of Korean media agencies reported on today. Now, I saw some like NewJeans supporters or some bunnies saying that why is HYBE bring back this old court decision from months ago and to have it circulate within the Korean media agency. But no, this is not old. It's something new, and the decision came out only yesterday on May 29th. So, in fact, actually, let's start here. So, case overview. NewJeans has come under legal fire after performing at a concert in Hong Kong. It was known as ComplexCon in Hong Kong, right? And they performed under the name NJZ. Despite the court having issued an injunction preventing them from engaging in independent entertainment activities, the court determined this was a violation of the ban issued in favor of their agency, ADOR, and responded by enforcing what's known as an indirect compulsory enforcement order. And I'm not, so it turns out, I told you this is the official website, seoul.scourt.go.kr, where you can enter in case number and you can see the progress on the case. So this is a particular case that ADOR has submitted back in April, on April 4th. And then the decision came out a couple days ago. Okay, so let me read you this article and translate for you. And then we'll go through each of them. I have other supporting materials to add as more context for this case. Okay, so let's start here. Title: NewJeans Hong Kong concert appearance backfires. Court rules unauthorized activities prohibited. 1 Korean billion per violation. NewJeans' participation in a Hong Kong concert has come back to haunt them after the court sided with their agency, ADOR, and issued a preliminary injunction. On May 29th, the 52nd Civil Division of the Seoul Central District Court issued an indirect compulsory enforcement order related to a previously granted injunction on banning the members from engaging in entertainment activities without agency approval or entering into new advertising deals. Indirect compulsory enforcement refers to a legal mechanism where the court orders monetary compensation as a way to pressure a party into complying with its ruling, used especially when direct enforcement is difficult. In Korean, we call it 간접 강제. And in fact, we had a hint about this back in March when the court made a injunction ruling. So this is Chosunbiz, and when they reported, at the end of this article, there is this portion that says, meanwhile, it was reported that ADOR did not initially request the imposition of an indirect enforcement fine when applying for the injunction. This type of fine serves as a penalty imposed when a court order is not followed. For example, requiring NewJeans to pay a set amount each time they perform without ADOR's consent. But such fines can be requested after the court issues its decision, if one of the parties fails to comply with that ruling. And remember, I told you, ADOR submitted this case on April 4th. And here's a timeline that I'm going to show you later. So after the court made a decision, the court grants ADOR's injunction requests 11-0, right? Independent promotions and ad deals and deals are banned for NewJeans, but NewJeans regardlessly performed at ComplexCon in Hong Kong, and then they filed an objection. But before April 16, when the court rejected objection, ADOR has submitted this request to court for the indirect enforcement. Okay, but curiously, the Korean media did not really pick up on this. So it was the first time that we heard about this case today. Okay, so let's go back to the article. So once again, this is not the same decision as the injunction ruling. It's different. Okay, and here's they're summarizing what has happened before. Or actually, they're looking at the actual ruling of the indirect enforcement. So according to the court's written decision, the judges stated the debtors, who are NewJeans members, are prohibited from engaging in the listed entertainment activities, either on their own, including through legal guardians, or through any third party other than the creditor, ADOR, without the prior approval or consent of the creditor, until the ruling on the lawsuit confirming the validity of the exclusive contract is delivered. The court further ruled, if the debtors violate this order from the date they received this original court notice, they must pay 1 billion Korean won, which is approximately 730,000 US dollars per violation to the creditor. They are also responsible for all legal costs associated with the application for this case. Now, did I translate? Hold up. Give me a minute. So when they said entertainment activities, here's I actually have it right here. There we go. So I have got this from the actual ruling of the injunction back on March 21st. 별지, and it says this. Activities as a musician, including writing lyrics, composing, performing, and singing, as well as related appearances on broadcasts and participation in events. And secondly, negotiation and signing of advertising contracts, appearances as an advertising model, and any other commercial activities based on the individual status or popularity as a public figure in popular culture. So these are things that you cannot do on your own. If you want to, do it under ADOR's terms, because you have signed a contract with ADOR. But if you do this independently, then you have to pay how much? 1 billion Korean won per violation. Now, another detail from the ruling is that it seems like when ADOR first applied for this indirect enforcement case, they requested the fine as 2 billion Korean won per violation, 20억 won. But then the court reduced to 1 billion won for some reason. And then also, what did they say? That they will have to pay these fines if the debtors violate this order, if the NewJeans members violate this order from the date they receive the court notice. Okay? 이 결정 정보를 송달받은 날부터. Okay? So receive this court notice. And when did they receive the court notice? May 29th. So what does it mean? This Hong Kong concert, ComplexCon, and all these, sketchy things that they did, selling their own merchandise, wouldn't count. Okay? At least according to this court ruling for this case. Because they said 이 결정 정보를 송달받은 날부터, from the date they received this order. All right, so let's move on. So that was a court ruling. We did this. All right. And then from here on, the article talks about the summary of what had happened before. Back on November 28, 2004, the NewJeans members held a press conference declaring the termination of their exclusive contract with ADOR. They notified ADOR that the contract would be considered nullified as of November 29th, citing the agency's alleged breach of contract. In response, ADOR filed a lawsuit on December 5th, seeking confirmation that the contract remains valid. As tensions escalated, especially after the members opened personal Instagram accounts and solicited new group name ideas, ADOR filed for a preliminary injunction on January 6th to prevent them from engaging in activities outside of the agency or signing advertising deals. Right? In fact, the user members, as it turns out, tried to sign independent deals without ADOR. But those companies that they reached out to contacted ADOR. That's how the company figured out. Right? On March, where is it? Yeah, and then the article says, despite this, on February 7th, the members announced their temporary group name as NJZ and released official concept photos and logo graphics. They also filed a trademark application for the NJZ name. And then on March 7th, the court held a hearing for the injunction case, and the members themselves attended in person. Then on March 21st, the court granted ADOR's injunction request, ruling in favor of preserving ADOR's position as a management agency and banning independent activities and advertising contracts. But NewJeans proceeded with their scheduled appearance at ComplexCon in Hong Kong, performing as headliners under the name NJZ and debuting a new song titled Pit Stop. During that stage appearance, they announced they would suspend further activities in respect for the court's decision. But ironically, NewJeans filed an objection to the injunction, even though they literally said that they respect the court's decision, which the court later rejected. The group then immediately filed an appeal to the higher court. So when did that happen? Filed an objection on March 24th, and the court rejected the objection and upheld the original ruling, and NJ immediately filed an appeal on April 16th. And then fast forward to today, May 29th, the court issued an indirect enforcement order with 1 billion Korean won per violation. Now, here's an interesting tidbit that the article included. Regarding the Hong Kong event, so this event and this event, and of course they're talking about probably their selling of merchandise as well. So regarding the Hong Kong event, the court stated, the debtors, NewJeans members, made clear, both directly and indirectly, that their intention to continue independent activities even before and after the injunction was issued. Let me read that one more time. The debtors made clear, both directly and indirectly, their intention to continue independent activities even before and after the injunction was issued. By performing at ComplexCon under a new group name NJZ and releasing a new song, they clearly violated the obligations set forth in the injunction. Given this, there is a strong likelihood that they will continue to violate the order moving forward. So, the court thinks the same as a lot of you guys, right? You guys are like, many viewers are like, okay, NewJeans are doing all these things on their own, and nobody's stopping them. Is there any way like the law can't stop them? Which is exactly why ADOR, filed for this case and submitted application request to the court for indirect enforcement, and the court thinks the same way. They sided with ADOR, and it's just follow the law. The court concluded that indirect compulsory enforcement was necessary, 간접 강제, to compel compliance with this original order. The judge also considered the conduct of the debtors, NewJeans members, after the injunction was issued including the violation of obligations, the anticipated damage to the creditor, the potential benefits to the debtors, NewJeans members, and the context in which this decision became necessary before ordering each member to pay 1 billion Korean won per violation to ADOR. But one more time, at least based on the text of the ruling, the Hong Kong concert wouldn't count as violation because it was before they received this order, and it was before ADOR submitted the application for this case. Okay, let me read that one more time. The judges also considered the conduct of the debtors, NewJeans members, after the injunction was issued, including the violation of the obligations, the anticipated damage to the creditor, meaning ADOR, and the potential benefits to the debtors, meaning NewJeans members, and the context in which this decision became necessary before ordering each member to pay 1 Korean billion won per violation to ADOR. Okay? Now, I'm not going to read this part, but just the last sentence. While the main lawsuit over the validity of the exclusive contract has yet to be concluded, the court has so far sided with ADOR in preliminary proceedings. The second hearing in the main case is scheduled for June 5th, 2025. So in a week, we're going to have the second hearing in the main case happening. So it gets kind of confusing. Which is why legal timeline is pretty handy in this case, right? So schedule June 5th, second hearing for the main lawsuit over the validity of the exclusive contract. All right. So to summarize, the original injunction prohibiting NewJeans from pursuing entertainment activities without ADOR's prior consent remains in effect. And as a result, the court has imposed an indirect enforcement order. 1 billion Korean won must be paid for each violation, and each member is held individually accountable, and they must also cover all associated legal costs. What else? The court's reasoning. Performing under a new name, NJZ, and releasing a new single, Pit Stop, was deemed a direct violation of the injunction. The court sees a high likelihood of further violations and deemed stricter enforcement necessary. And taking into account the members' actions, potential damage to ADOR, and other circumstances, the court set the penalty at 1 billion per offense, which is 1 billion less than the original amount that ADOR has initially requested for. Key takeaways. The outcome of the main lawsuit could dramatically reshape NewJeans' future as a group, but if multiple violations are acknowledged, the total compensation could reach tens of millions of won, significantly increasing legal and financial risk, and this case could actually set a new precedent in the K-pop industry for how exclusive contract disputes are handled in court. Now, here might be some potential questions asked by people. Are the NewJeans members really banned from all activities? Not entirely, but under the court's injunction, which I just showed you, and this is the definition of entertainment activities. They're not allowed to engage in any entertainment activities like concerts, endorsements, or releasing music without prior approval from ADOR. If they do, they could be fined 1 billion Korean won per violation. So in practice, their activities are effectively on hold for now. Some NewJeans fans might say that this is too cruel, like 1 billion Korean won per violation. Well, don't violate. If you want to do all these entertainment activities, do it under ADOR. That's what the court says. As it is, according to the contract that you have signed with ADOR. What else? Is it still a legal violation if they perform under the name NJZ? Yes. Changing the group name to, I don't know, some random, what's the Instagram name that they're using right now? MHDDH? 해야, right? Even that doesn't change the legal situation. The court sees this as continuing independent activities outside the terms of their exclusive contract. And in fact, performing and releasing a song under NJZ was specifically cited by the court as a violation of the injunction. Right? Where is it? NJZ. NJZ라는 새로운 그룹명으로 공연하고 신곡까지 발표함으로써 so the court acknowledged the fact that they performed under the name NJZ at ComplexCon in Hong Kong and released a new song or performed a new song. And then when can we expect a final decision? The appeal for the injunction is currently underway at the Seoul High Court. As for the main lawsuit over the validity of the exclusive contract, the second hearing is scheduled for June 5th. A final ruling could take several more months to over a year. And if the case goes to appeal, it could stretch into a 2 to 3 year legal battle, which is why a lot of NewJeans fans are saying, go back to ADOR. Otherwise, you're going to spend a good amount of your youth doing legal battles, wasting away your youth, which is super unfortunate. All right, what else can we discuss? The 1 billion penalty per violation. What does this mean? So, this ruling wasn't just about collecting money per se. It's a legal warning designed to apply pressure, psychological pressure and legal pressure on NewJeans to stop any further independent activities. Because what did the court say? They explicitly mentioned the possibility of future violations, signaling its clear intention to control not just past actions, but also anything that might happen going forward, right? And why the use of the name NJZ was a key turning point, because this wasn't just a one-off performance. NewJeans didn't just appear on stage; they also filed a trademark application for NJZ, which I have recently covered. And they also tried to fast track for one of the applications, but then the word spread online, and then they canceled the application for fast track, and then they even sold goods, merchandise. So, to the court, this wasn't a coincidence, because they did all these things and released official branding materials as well, and it looked like the group NewJeans was trying to commercialize a new identity even before the exclusive contract issue had been resolved. And in that sense, NJZ became evidence of intent to operate independently, which played heavily against them in the court's judgment. Now, so what's going to happen now? ADOR won the injunction before the main trial, and that kind of matters, because injunctions often serve as early, indicators of how the court is leaning before the full trial. And the fact that ADOR won the preliminary injunction suggests that they're likely to have the upper hand in the main lawsuit as well. And that's what a lot of lawyers say as well. There's no chance that NewJeans can throw this around, even though they have now hired a very seasoned lawyer, but that's not really going to change anything. And the court's decision to restrict the members' activities so strongly implies that it sees the contract as still valid, which is another sign that ADOR's case has legal weight. Okay, so I think I covered everything that I've prepared for. And then, we already, knew that they weren't supposed to do any entertainment activities or commercial activities, even though, they want to, appear in advertisements and want to sign deals with advertisers. But what really happened is that all those advertisers gradually have changed the models from NewJeans to someone else. Some other celebrity. So there you go. Once again, here's the timeline. And the next schedule is June 5th, the second hearing for the main lawsuit over the validity of the exclusive contract. So let's see what happens then. All right. If you have any opinions that you have, feel free to share. But in this video, I have emphasized some points and intentionally read some points multiple times to hammer them down, because I recently saw people like saying different things that weren't specifically mentioned in the video. So yeah, let's stay true to the facts and stick to the facts. All right, and stay positive, respectful, and classy. See you guys later. Bye bye. Whoop. Wait, I didn't turn on. Hey, why did I not turn this on? Did I not change the dates? I should right now. D11, D12, D22. Right? Here we go. Almost there. Peace.